A woman got DACA back in 2013, married a U.S. citizen years later, did everything by the book, filed her husband's petition, applied for advance parole, flew abroad, came home in January 2024, inspected at the airport just like her lawyer told her to expect. That trip was supposed to be the fix. Instead, her case just became the reason thousands of people's travel plans got a lot more dangerous. On August 13, 2026, the Board of Immigration Appeals issued a decision called Matter of Delcarmen-Lara. It overrules a rule immigration lawyers have relied on for 14 years. If you have DACA, temporary protected status, a pending case built around advance parole, or you entered the U.S. without inspection and were planning to travel to fix that, this is the update to actually understand before you book anything. Here's the old rule, the one that just got erased. Back in 2012, the BIA decided a case called Arrabally and Yerrabelly. It held that a temporary trip abroad on advance parole wasn't a real departure under immigration law, at least not the kind that triggers something called the unlawful presence bar. That distinction mattered enormously. If you'd been in the country without status for more than 180 days and then left normally, you'd trigger a 3-year bar on returning. Cross a full year of unlawful presence, and leaving triggers a 10-year bar instead. But advance parole was treated differently. It let people travel, come back inspected, and fix an old illegal entry without tripping either bar. That's the exact loophole thousands of DACA recipients and marriage-based applicants built their entire path to a green card around. Here's where it gets worse. According to Murthy Law Firm, one of the immigration firms that flagged this decision within hours of it dropping, the BIA didn't just tweak that rule. It reversed it completely. The board looked at the plain dictionary meaning of the word depart, to leave, to go away, and decided nothing in the statute actually carves out an exception for advance parole. So starting with this decision, leaving the country on advance parole counts as a real departure. If you'd already crossed 180 days of unlawful presence before that trip, you can now trigger the 3-year bar. Cross a full year, and it's the 10-year bar instead. If you or anyone in your family has DACA, TPS, or a pending marriage-based case, go ahead and subscribe now, because how the BIA and USCIS implement this in practice is still developing, and we're tracking it closely. Now, before anyone panics and cancels a flight that's already been through consular processing, there's a critical detail here, and it's the one thing worth sitting with. This only applies going forward. The board ran what's called a retroactivity analysis, specifically because it was overruling 14 years of precedent people had genuinely relied on. Its conclusion? The new rule is prospective only. If your advance parole trip already happened before August 13, 2026, it's still judged under the old Arrabally rule. You're not retroactively exposed. But any trip on or after that date plays by a completely different set of rules. And that line, one single date, is now doing an enormous amount of work in people's lives. Think about what that actually means for someone mid-plan right now. Say you entered the U.S. without inspection years ago, crossed without ever being checked or admitted. You've got DACA today. You married a U.S. citizen. The old playbook was simple. Apply for advance parole, travel for something real, a sick relative, a family emergency, come back through an airport, get that inspection stamp, and suddenly you're eligible to adjust status from inside the U.S. through your spouse. That playbook still technically works for fixing the entry problem. Advance parole still gives you that inspection stamp. What's changed is the price. If you've built up more than a year of unlawful presence somewhere in your history, that same trip that used to fix everything can now hand you a 10-year bar instead, one that requires a separate waiver, filed on top of everything else, with no guarantee it gets approved. There's one group this hits less hard, and it's worth knowing if it's your situation. If your unlawful presence never actually accrued, say you filed a complete good faith asylum application while still in a lawful visa period, and it's been pending for years, that pending case generally stops the unlawful presence clock while it's active. Travel on advance parole in that situation still counts as a departure now, but without the underlying unlawful presence, there's nothing for that departure to trigger. Same trip, same new rule, Completely different outcome. Because the number sitting underneath it is 0. For everyone else, immigration attorneys are converging on the same blunt advice. Don't travel on advance parole right now without a lawyer running your specific unlawful presence math first. That was already good advice before this decision. Advance parole re-entry was never guaranteed, since customs officers retain discretion to deny entry even with a valid grant in hand. Now the downside, if you do get back in, has gotten dramatically worse for a specific slice of people. Picture 2 DACA recipients side by side, both booking the exact same flight for the exact same funeral abroad. One entered the U.S. lawfully on a visa years ago and overstayed by roughly 3 months before things got sorted out, well under the 180-day line. The other crossed the border without inspection entirely and has been undocumented for 6 years since. Same emergency, same flight, same advance parole approval letter in hand. One comes home to a green card interview moving forward normally, no bar triggered at all. The other comes home to a 10-year bar and a waiver application neither of them saw coming when they booked the ticket. Here's the honest bottom line. This decision doesn't kill advance parole, and it doesn't affect everyone who holds one. If you have little or no accrued unlawful presence, the calculation barely changes. But if you've got real unlawful presence sitting in your history, and a trip was part of your plan to fix an old entry or reunite with family abroad, that trip now carries a risk it simply didn't carry before August 13th. A risk that can turn an easily approvable green card case into one that needs a waiver nobody can guarantee. This video is for general information only and does not constitute legal advice. It reflects the BIA's decision in Matter of Delcarmen-Lara, 29I and N, December, 830 BIA 2026, and reporting from immigration law firms current as of August 2026. Unlawful presence calculations are highly fact-specific. Anyone considering international travel on advance parole should get individualized legal advice before leaving the country, not after booking the flight. Subscribe, because if you thought advance parole was still the safe fix it used to be, that assumption just changed on August 13th, and it's exactly the kind of update worth catching before your next trip, not after.